follow-up to the presentation that was given on copyrights and trademarks a couple of weeks ago. I'll be talking today about patents, and I've titled this, What You Need to Know About Patents, to emphasize that this is a very practical talk focused on what you as administration, faculty, staff, students need to know in your daily work. It's not a talk about patent law, what the law is. It's really focused on what you need to know so that you know what actions you need to take to help make sure you get the protection you need and don't stumble on any of the problems that people often make, or the mistakes people often make when interacting with patents. And as Ryan said, please feel free to interrupt me with questions. It's really helpful to keep the conversation going and to make sure that what I focus on is what's most important to you. I've listed the 3 most common ways I think you'll interact with patents, and of those, the first of the 3 is most likely going to be the most common, which is obtaining patent protection for inventions. If you're doing any kind of creative work here, it might result in development of an invention, then you may be involved in the process of trying to obtain patent protection for the invention. With clients who I work with, that's the most common way they interact with the patent system. And so I'll talk a lot about what's involved in even determining whether anything you're creating might be patentable, and then how some of the rest of the process works. The other 2 ways will be less frequent for you. One of them would be to, if you make use of anyone else's patented invention, and what you need to do to make sure you don't infringe on anyone else's rights or get the permission that you need. And then the third way is if you, and when I say you here, might be if you individually own a patent or if the university owns the rights to a patent. What's involved in granting permission to other people to make use of patented inventions that you own patents. I'm going to describe a hypothetical situation so that I can keep referring back to it in the rest of the talk. And in previous sessions, we found it helpful. People will refer to this hypothetical situation when they ask their questions, so we all have some set of facts to refer to and make the discussion a little bit more concrete and less abstract. Because these discussions about intellectual property rights can often get very abstract and hard to follow otherwise. So here's the situation. There's a professor and a student at a university, let's say it's here at Gallaudet, who invented a new mousetrap. And it's really not that important for our purposes exactly what's new about this mousetrap. We'll just assume there's something about it that makes it work better than previous mousetraps. The second important fact is that it includes a hinge here that already existed and was patented by someone else. So it incorporates an existing invention. And the third fact is that the professor and the student want to publish a paper about this invention. And you'll see as I talk through why these facts will all become important. Before saying what patents protect, let me mention what a patent is briefly. A patent is a kind of legal protection for an invention like a mousetrap. If you have a patent on a mousetrap, it gives you the legal right to prevent other people from making, using, or selling that mousetrap without your permission. That is what a patent is. It takes the form of a document that we usually call a patent that describes the invention so that anyone who reads it will know what you have the right to. But the document gives you legal rights, and that's really what you own, are the legal rights. And you are free to give other people permission or not to use your invention for any reason or for no reason at all. In that sense, it's very much like a copyright. Copyright applies to what we call works of expression, like written works, artwork, music, film. Patents apply to inventions. Inventions are things that are practical, that do things that are useful. And here I've got some illustrations of the main categories of invention that are patentable, and that distinguish what's patentable from what's copyrightable. The first is machines, devices. Often in patents we use the term apparatus. Physical products that do something useful. I think that's what most people think of. The famous historical examples, a steam engine or light bulb. That's one category of patentable invention. But now, today, there's very large numbers of patents granted on chemical inventions, biological inventions. What people don't often know about are patents on processes. This is supposed to show an oil rig. Throughout most of patent history, processes were industrial in nature, like for extracting oil or manufacturing physical products. These days, and this is where I spend most of my time, you can get patents on software. And software you can think of as something like a process or a product or a mixture of the two. Very often, there are innovative aspects of software that are like a product and aspects of it that are like a process. And as long as any of these things do something useful, you can obtain patent protection on them, and thereby obtain the right to prevent others from making, using, or selling any of these. And for any of you here who are doing work on processes, including software, this is an important thing to know about.
Maybe I can forward the slides for you.
Sure. Okay. I've told people in the previous versions of this, if there's one thing to take away, I think it'd be this slide. I'll just give you a minute to read it. When you're doing work that might result in something patentable, these are the key questions to keep in mind. The first one being the most important, really, the most fundamental question. Is this product or software or device, does it do something that was never done before? That might take the form of the second question. But it does something that was done before, like catch mice, but do it in a different or better way than previous inventions. That can make your invention patentable. Does it provide any benefit over other ways of solving the same problem? Your mousetrap, is it faster? Is it smaller? Is it easier to manufacture? Is it lighter weight? Any of these features could potentially make your invention patentable, even if the invention solves the same problem as previous inventions. Or does it represent the result of any experimentation that you had to perform? Did you have to try things and fail at them before coming up with the solution? These are all clues that what you've created might be patentable. I put these here not to say that if you say yes to any of these, then your invention is patentable, but rather that it should raise a red flag in your mind to investigate whether your invention is patentable. And here's some benefits of patents, some of which are the same as benefits of copyrights and trademarks. One is that when you obtain a patent in the US, you get protection throughout the entire country. You can obtain patents on the same invention in multiple countries and obtain protection in multiple countries, as you said. I think the second point is probably the most important. Broad scope. What I mean by that is that, let's go back to the mousetrap. Let's say that what's new about it is that the trap part connects to the hinge in a new way. If your patent attorney does a good job and writes that patent thoroughly and broadly, then you can obtain protection for that mechanism in the trap, regardless of, let's say, what kind of wood the base of the trap is made out of, what other kinds of materials are used, regardless of the size of the mousetrap. The patent can protect a wide variety of ways of implementing the same invention. Unlike copyright, where I'm sure you know that many books have been written with the same plot. I think Romeo and Juliet, right? How many different books have we read that have the same basic plot? Copyright protects essentially the words that you use, not the idea behind them. With patents, you can get pretty close often to covering the idea behind an invention and not just the specific way in which the invention is built. Yes, okay. Oh, sorry, back one, yes. Here's some pitfalls. And I mentioned specifically pitfalls that can result from confusing how patents work with how copyrights and trademarks work. You can obtain copyright protection without submitting a copyright application to the Copyright Office. Just by writing a paper, you obtain copyright protection. You can submit an application to the Copyright Office to obtain additional benefits, but it's not necessary. With a patent, you must submit a patent application to the Patent Office, and if you don't, you obtain no patent rights. So an application is absolutely required. The next point is that if you publish information about your invention before you've submitted a patent application, you can forfeit your patent rights. In particular, and I say this particularly to university clients where publication is highly valued, sought after, and often done quickly and frequently, that if you publish information, question?
I was going to ask if you could elaborate a little bit more about that particular point. So every time, for example, a faculty member comes up with a new idea online or design or teaching or a methodology, bilingual methodology, because everything that our faculty do here is the first time that we are doing this. There is no precedence for
think I was able to keep track of the different parts of it. So let me answer the specific question about what you can do after the fact first, which is that in the US, you do have 1 year after making information about your invention publicly available in which to file a patent application. So today, if there's anything that was first revealed less than a year ago, we still can file a patent application for it in the US, although we've lost rights outside the US. The US is more lenient than other countries in that way. The US gives you what's called a 1-year grace period. So that's one thing we can do to recover for anything that's been what we call publicly disclosed already. The second is that we should be keeping track of any further improvements to things that have been revealed publicly, because those improvements might be significant enough to be patented, even though the original version of the invention can't be patented anymore. What's unfortunate,
No, please continue.
What's unfortunate is that we would have to prove that the improvement is a significant enough improvement over the original version to merit patent protection. In other words, your own previous work that was made public will be used against you.
Just a follow-up question. When you're talking about improvements made, in this realm, software changes are improved and updated regularly, so a product has to be improved also. Is that sort of an update, a part of what you're talking about, or does it have to be a design improvement on the original product that qualifies for that act?
It's hard to answer in general, but we usually like to think of there's a new feature that you've added that provides the user of the software with a benefit over what happened before. So, for example, a bug fix wouldn't be considered an improvement. That would be patentable. One guideline you might use is this new feature something that a competitor would see as valuable enough to want to copy? If it is, then it might be at least worth thinking about patenting. Another way is, would it just, I know this in the context of universities, often we're talking about products that are not being sold. They might be being given away. But in the commercial context, we ask, is this improvement significant enough that you could charge a customer more for it? And whether you will charge more or not, asking yourself that question is useful as a guideline for helping determine whether it's a patentable improvement or not.
I have a question specifically around this title, this slide, around trademark. My department here, over at the Clare Center, is charged with disseminating information throughout the nation. And we provide technical support and so forth. We do have a theme of being a one-stop shop for everything deaf and hard of hearing. We have many articles and publications, and now we're starting to see something very similar pop up across the nation in other places. Should we trademark that? Because we were first, and this is very much tied into the work that we do. So do you get like an automatic trademark there, or is that different, like a patent?
So I think this would be a question for Brenda, who was here previously as the trademark lawyer. This sounds to me like most likely a trademark question, possibly copyright, not patent.
You have another question?
I wanted to apologize
good question. I'm glad you raised it because you can, and you can do that whether or not you've missed the 1 year mark. In fact, from the beginning, it would be a good idea to consider whether multiple forms of protection are applicable and whether they're valuable. For software, often multiple forms of protection like copyright, trademark, and patent are all applicable. And then you need to look at what kinds of protection do each of those provide and whether it makes sense to seek out more than one of them. And that's in part based on how much legal protection each form of protection provides and based in part on the cost of doing it. So in the last session, someone asked about relative costs. And usually copyright is the least expensive and fastest and easiest to obtain, even with a copyright registration. Trademark would be the next most time-consuming, expensive, complicated, and patent the most. So we usually reserve patent protection for the most significant innovations that will have the highest commercial value, just based on a cost-benefit analysis. But for software, you can obtain copyright protection for things like the user interface, how it appears. You can also obtain copyright protection for the code that's written, which is primarily protection against an employee or a contractor or a partner who has access to the code who might copy it. Very often we use copyright protection when there's an outside software development firm, let's say, that's hired to do some of the work. And we want to make sure that they don't go and copy that code and use it for another customer of theirs. And I don't know whether Gallaudet is ever involved in doing that or if everything is done in-house. But copyright protection can be very valuable for that. And it's also, if someone just copies your code, copyright protection is very easy to enforce in that kind of situation. And the downside of copyright is that it's relatively narrow. If you get a copyright protection on your user interface, someone could copy the basic idea, make some changes to how it looks, and evade copyright infringement that way. But it's always important to think about multiple forms of protection, and it can get quite complicated.
I'm concerned. I'm already seeing one 501c3 nonprofit trying to take her idea to another country. Ghana. I see the efforts there, and I thought to myself, gosh, how do we stop that? They had no background, no standing, foundational materials. So we think about, they were trying to create this for their deaf and bilingual individuals in their country. And I thought, how could that be? So it's already happening, Melissa, where, so it's interesting. And that, I think, is a conversation for another time, and we certainly do need to attend to that quickly. I am curious, and I'm going to pick on Larry a little bit here, and then there was another one. In medicine, they're probably the only clinic in the United States that provides audiology services in both languages. It's a supported process of providing care bilingually. It's the only one in the world that we know. Maybe there are other individuals out there practicing a process of bilingual integrated into their audiology services, but nothing like our clinic. Is it possible to patent healthcare practice? It's a methodology of providing care that recognizes the brain's ability to absorb languages, to learn and adapt in using other sensory skills than hearing.
It's interesting. This has now come up, I think, in each of the sessions. Questions about patenting methods that are performed manually, which under the current state of the law is very hard to obtain patent protection. And I'll just tell you that over lunch, Steve Gold and I were talking about this issue because it seems like a general issue that could be a limitation on Gallaudet being able to obtain patent protection for its innovations because they take this form. And we were thinking about, this is a separate conversation, longer term strategies for changing the law to eliminate or minimize this restriction. The way the law works now, it is easiest to obtain protection for methods that are performed by a machine in whole or in part. And the law makes it very difficult to obtain patents for methods that are performed manually using the human body. That law wasn't always that way, and there's not an absolute restriction, but it's become quite challenging as a result, mainly of a series of court cases that I don't think were intended to result in this restriction. They were mostly intended there's somewhat of a backlash to patents on software that were written very, very broadly to include methods that weren't performed by a computer. I think the laws had some unintended consequences. So I think this is probably a bigger discussion for us to have about what we can do, both under existing law, to file patent applications that would cover this kind of innovation and maximize the likelihood of those patents getting granted. But the bigger conversation is what can we do to try to steer the law in a different direction? And we just started talking about this over lunch, but I think it's a different topic, but something we should keep talking about.
And Robert, just remember to take advantage of our congressional relationships. We have many of them, and they like LA right now. We are a hot commodity up there. So just think about that. Strike while the iron's hot with Congress. But I know it's more than just about that.
Yes.
You know,
And, well, let me just say on that point, the laws move in this direction almost entirely as a result of court decisions. So it could be moved back either as a result of the courts or legislation. Let's keep talking about it. Okay. Other questions or?
Yeah, can you go back one slide? I don't know if you have seen the concept of using open source platforms.
What did you mean by that can't be patented? Did you say that again?
I am familiar with open source. I didn't intend to say that open source can't be patented. Is there something else?
There's one question also. I'm kind of a militant, free, open source kind of guy. And to answer your question about outside contractors, I was a full-time employee here. Now I'm an outside contractor here. So, yes, Gallaudet does to outside contractors for software.
So generally with open source software, if you're using someone else's open source software, generally you are not going to be able to patent things that you make using that software. But it can get very complicated because there are many different open source licenses out there. These are basically legal documents that define what your rights and responsibilities are with respect to the open source software that you're using, and every piece of open source software has its own open source license attached to it. And you need to read that license and understand it. There's a few dominant ones, but they don't all say the same things about patent rights. So if you are doing work that you think you might want to patent, it's important that you, before you use any open source software as a part of that work, that you read, ideally get the advice from an attorney about whether using the open source software will prevent you from patenting something you develop using it. You may not like this term, but among patent lawyers, we talk about open source software infecting software projects. You may call it freeing them. But from the perspective of trying to make sure that any work a client of mine does keeps open the option of being patented, we like to make sure we look at the open source licenses that are being used to make sure they don't foreclose the possibility of obtaining patent protection. I don't know if that answers your question, but it's the main issue that comes up with open source and patents.
Thank you.
So we don't have too much more time. I'm glad we're making this very interactive. I probably won't get through too much more of the presentation, but there is a much more detailed version of it that you'll all get a copy of. I think it's certainly better if we spend time here on people's questions.
As President Cardano, I was not also able to visit here a couple of weeks ago for the trademark and copyright presentation. Will that presentation be disseminated?
Yes, it will be. Tiffany and I are actually coordinating to make sure that everyone gets a copy, and do please share those with your team, colleagues, students. We encourage more conversation like this. And I actually have a question to ask you. Can you please talk about the different type of patents, provisional, non-provisional, and designed, and how that may apply to the university?
Sure. Let me answer the question about provisional applications in connection with the need for speed in filing patents. I'll try to combine that together. Under the current law in the U.S., it's very important when you develop something that's patentable to very quickly determine whether to file a patent application for it, and then to file the patent application as quickly as possible. Because if you and a competitor are working on the same invention at the same time, and both of you file patent applications for that invention, it's whoever filed the patent application first that's entitled to pursue the patent. So the filing date at the patent office is really critical. Even if someone else files one day before you, they have what's called priority over you, and you won't be able to pursue your patent anymore. This is a change in the law as of about 5 years ago. So if you have heard that in the US, what's important is who invented or conceived of the invention first, that's important. That's no longer true. I always like to let people know, because that change in the law is not something that a lot of people who aren't patent lawyers have heard about, even though it's been changed for a few years. The US had this first to invent system for so long that many people still think that as long as they documented the fact that they invented something on a certain date, that they can wait until later to file their patent application, because that documentation will allow them to overcome someone else's patent application. That's no longer true. So right now, it's very important for us to try to file patent applications as quickly as possible, particularly in fields where we know there are other people working on trying to solve the same problems quickly. For me, I work on software patents. Almost all of my clients are in that situation, but some fields move more rapidly than others, and we know there's multiple teams of people all working as fast as they can, and they all know they're working on the same problems as each other. And I've worked on patent applications where there's been as little as a week difference in the filing date, and that's critical. So, to come back to the question about provisional applications, a provisional patent application is essentially a smaller, scaled-down patent application that can be written and filed more quickly and less expensively than a regular patent application. So it's something that we often do. We often file provisional patent applications initially in order to get them on file quickly and less expensively. Once you file a provisional application, it buys you a year of time in which to file a full, sometimes called utility or non-provisional patent application that satisfies all of the legal requirements. So that is whether to file a provisional application initially or not is a strategic decision that's usually made in consultation with your patent lawyer. It will depend on the budget and priority of the project. There are a lot of misconceptions out there about provisional patent applications. I'll just mention one, which is that this is the misconception that you can write a paragraph describing your invention and submit it to the patent office. That's almost never true. You still must submit a full, detailed technical description of how your invention works. And in recent years, the patent office has become more strict about enforcing that requirement. And if you don't satisfy it, it could cause your patent to be rejected or later invalidated. Brian mentioned a design patent application. It's not used very frequently, but it's important to know about. A design patent covers the what's called ornamental appearance, but you can think of it as the visual appearance of a product. So a sneaker might have a certain shape that looks appealing. You might get copyright protection on that and design patent protection on it. The reason you would seek design patent rather than utility patent protection for it is that if the shape doesn't do anything useful, but what's new about it is how it looks, you might seek design patent protection. Clothing manufacturers like sneakers and sporting goods, snowboard manufacturers, they often use design patents because they want to make sure no one else can copy that distinctive appearance of their products, even if it doesn't make the product do anything useful. And that might apply to some work that people here are doing.
Sure, right here.
Okay, yes.
So, I'm starting small, working on business, and I also went to the bison competition pitch and presented there. I think that there could be some risk in someone in the audience perhaps copying my idea just from that public presentation. How can I prevent that? And how do I think about those three types of patents that you just explained? How does that apply to a business and not a product? And what might those costs be for three types of patents?
Yeah. So, very often, the business protection would be covered by trademark if you're talking about the name of the product or the logo. Trademark covers what we call brand identifiers. The Coca-Cola logo is a classic example, the Nike swoosh. Those are covered by trademark protection. They're the things that are associated with the reputation of the company or the brand. Copyright would cover any written materials, documentation of your products, the user's manuals or advertisements or marketing materials for it, videos, those kinds of what we call expressive works. And then if what you developed is a product, that is something that would potentially be patentable. Now, when you said, what can you do to prevent someone from copying you? Really, in practice, we can never stop anyone from copying. All of these forms of legal protection are there to sometimes deter people from copying you and to give you action that you can take after the fact if someone does copy. What I would always advise people before going into a competition, and although I know that the amount of effort and cost can be quite high, is to at least consider what different forms of legal protection you might have available, and the patent is one of them. And think about even filing a provisional patent application before the competition. Does that answer the question? So you can file any patent application on your own. I do have clients who do it. The government patent office filing fee is around $100. Maybe it's because I'm a patent attorney. I wouldn't recommend doing that. Yeah, which is relatively low compared to what you pay an attorney in filing fees to do it. But there are lots of materials out there that you can use to help you write your own patent application. It'd be much more expensive through an attorney, but it would be better than not having any protection at all, yes.
Ryan, and the student also.
Would you mind, do you apply on the internet or?
By the way, she has a great idea. So this brings me to say that I would suggest for every pitch group that you should invite the lawyers to come, Ryan, and let the students ask those very questions, and then also develop a strategy as a competitor of what you want to do. And that should be a part of every pitch process. And we will pay for the hour, hour and a half, 2-hour consultation for the lawyers to work with you.
Awesome.
So I'll leave that for you to figure out the details from now on. Ryan?
Awesome, we're gonna have an orientation today at 5 o'clock.
Yep.
I'm so excited.
Me too.
We're gonna get together and talk about all of those details, and not just for you, for students who have fantastic, innovative business ideas, but for faculty and staff who, or visiting fellows or researchers who often come here. You want to be careful how you reveal your information to these visiting fellows and visiting professors, right? You don't want to give away your secret sauce as you're doing this, right? And so your focus really is on the secret sauce, right? Protecting that. Am I close?
Yes. Yes.
Protecting ourselves
Yes.
in the process of, getting copyrighted or patented, but there needs to be some like stopgap solutions for
Right.
protecting the secret sauce.
So as we said at the beginning, this is just the beginning of what we hope and know will be ongoing conversations about this, including development of some policies and procedures for standardizing how this is handled. Part of what we can do is give people more guidance about how to share without sharing in a way that would jeopardize your patent rights. I often advise clients, I'd like the term secret sauce. In most inventions there is something that's really at the core of what's innovative. And it's very often possible to talk with someone else at a high level about your invention without giving away the secret sauce. And that's one way to satisfy your desire and need to share without jeopardizing your patent rights. I would advise that we engage in some training about that, including potentially going over specific examples, because knowing where to draw the line can be challenging.
And
Thank you
I
so
just
much.
want to say that there's about 5 to 7 minutes left. Can you give briefly to show the audience the rest of the slides on the PowerPoint,
Sure.
just to highlight something that might be coming, and I can advance the slides for
Okay.
you.
Yeah. Why don't you advance them, and maybe if people have questions that pop up,
Sure.
they'll do it based on what's on the slides. We could probably skip these. I think this is where I've ended before. If it, oh, go ahead.
I was just going to suggest that the university have some sort of a central official policy, I don't know if it's a policy or an office, where we might be able to report these sorts of things. It seems like we don't have that type of warehouse.
I can answer that question for you, may I?
Yes.
Nice to meet you.
Nice to meet you, yes.
Finally have the opportunity to meet.
Just want to make sure that the university stays their potential earnings, savings, and stays within the university, because it seems like it's not complete.
So two things that I would say, very quickly, I just want to thank everyone for coming, for those of you that are here. I appreciate seeing the faculty, the Clare Center representatives, and Gallaudet's original or older strategic plan actually had the charge to develop IP policy, and upon coming in, I said, so where is all of this? And I realized at that time that there is no way to just leave faculty to make these applications to file this. So then, you may have met Steve Gold, who was here earlier. He is the person that I have contracted with to then contract with Robert and get the support for the university as a whole for designing the property correction, the IP patents for people within our community, faculty, staff. So this is just part of that. When we are ready to roll out that policy, and you're going to be helping with that effort and creating it, we are in the process of developing that language. And so this met one of the urgent needs that we have identified as an institution, and I predict that we will have some sort of an office or a staff that will support this function down the road. It is inevitable because we have to get smarter about protecting our inventions as a community, and we've been letting other people take them and capitalize on our intellectual property and make profits monetarily off of this, and it's time for our community. So that's why he is here. This is just an introduction to all of you to start awareness. We plan to build it. If you have any future questions or concerns that come up, do certainly contact the provost's office or contact the office of the president. We will get you in touch with Steve or Robert. Steve Gold is our contact person, and if you need to, Melissa knows him, anyone else needs to reach out, he might be able to manage through the process until we have all of that set up internally. But right now, it's a bit hit or miss. We're doing the best that we can, correct?
Thank you very much, President
And
Bernard.
I'm glad you're here.
Great. Thanks very much. I think we're at time, and yes, for all clients who I work with, it is too much to ask individual people to stay on top of all of this and manage things individually, and that's why we're working together to develop some policies and procedures and centralized information that everyone can have access to help guide them through the process so people aren't doing it on their own.
It looks like there's one last question over here. I actually have two questions related to what was asked earlier about your business. And if I understand correctly, there are two ways to apply for a patent. One could pay for that on their own, or contact a company, FSH. Did I hear that correctly? FSH STEP is a program that supports people who are applying for a patent. A person may be applying for a patent and they will reach out to this organization for help. And the company will take an amount of equity, 5%, for their role in this working relationship.
Yeah, I can't speak for any individual company that's out there. I know there's a large number of sometimes called invention promotion or invention commercialization companies. I can say that there were a large number of them that were basically defrauding inventors. It became such a problem that the patent office developed its own department to try to educate the public about these. So although I wouldn't say that they are all not serving the interest of inventors, I would be very wary of them and investigate any companies like this very carefully before working with them. Many of them are not law firms, and one of the things that means is that the information you share with them is not protected by attorney-client confidentiality or privilege like it would be with a law firm. So I would say, one of the things you could do is go to the Patent Office website and look at its, the page on the site that's about what they call, I think, invention promotion companies. And you can look up their list there to see. So again, I don't want to speak highly or poorly of any individual one. But I personally am wary of them for that reason.
So with that, was there another question? I should say that Tiffany is going to send out a PowerPoint presentation to everyone, and if any additional questions come to mind or any clarification, we are going to figure out the best way to make note of those and communicate any questions, concerns, research that people may have and want to share. So just keep all of that in mind, and we will get back to you about how to best communicate that. Because this is not the first or the last time that we're going to have these sorts of conversations in the community. It's an ongoing effort.
Just wondering if there are any plans to develop some sort of a committee with all of these varying departments and individuals who are engaging in this work.
Certainly open to that idea. Recognize the importance of collaboration. You know, there are some consortium university partners like GW, for example, that have a wonderful technology transfer office and other programs and services that support intellectual property and others. So I think that, you know, we got to put it on the table. A committee could be helpful. I think what's most important is for us to get a pulse of what's happening in our own university community, and then figure out the way forward from there. With that, yes, one more question?
Maybe we could talk more later about this, but what is the role that we as, as a university that receives federal funding, is that creating limitations for trademark, patent, copyright? That's also an important boundary to navigate.
So with respect to patents, I'll just speak to patents. The primary impact of receiving federal funding is that when you file a patent application, you have to state in it that you've received federal funding for the invention, and you state the grant number, and so on. And then it means, usually under the contract in which you receive funding, that the federal government will get the right to use the invention. Otherwise, the patent is yours, as in any other case. The government just wants the ability to use your invention that it funded without having to pay you again for it. But you then can sell the patent or license it to other universities or companies just as if you hadn't received federal funding. That's how it works 99% of the time.
And that's why we've got people like you who are just geniuses. Thank you very much for your support. That's a good one. Great point that you've made. Good one. All right, thank you again for your time. And safe flight back. And look forward to seeing you sooner rather than later.
Thank you. I've been told that there's an interpreter here for another 25 minutes. If anyone wants to ask more questions, I'm glad to stay. Although we're officially over.